Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Raketa of Raketa Law, a small law firm in central Minnesota. And today I'm coming to you with an update on the KRAKEN lawsuit. Yes, this is Sidney Powell's lawsuit in Georgia. However, the KRAKEN lawsuit extends beyond Georgia. That is the idea behind the KRAKEN. Many tentacles or whatever going to all sorts of places, I believe. That is the idea anyway. But Sidney Powell's lawsuit has run into a bit of a hurdle in the 11th Circuit Court of Appeals. And this relates directly to the previous video I did on the KRAKEN lawsuit following the Sunday order earlier this week. It is now Saturday, December 5th, as I'm recording this. And I wanted to get this information out about what is going on in that suit. Because you may be seeing headlines out there that the 11th Circuit has tossed out Sidney Powell's case or something like that. It has not actually done that, but the effect of it is arguably pretty devastating to the case. But I want to point out that this effect was brought on by the actions of Sidney Powell and her team because they basically made a gamble decision, which, you know, sometimes that's what happens in court is you can see the outcomes going a couple different ways. And if you're wrong, there could be consequences. If you're right, there could be great rewards. You know, it's all a balancing test and strategy. And in this case, the strategy did not work out for Sidney Powell. However, the case is still going and still will be proceeding in district court as it already was, with a few minor adjustments to the schedule. And that's what we're going to talk about here. So, as a brief intro to what was going on, if you missed it, on Sunday, the Sunday after Thanksgiving, the court in Georgia, the district court in Georgia, issued an emergency order. And that emergency order granted a 10-day stay or injunction on the ability of Georgia officials to update, alter, or delete any software from the Dominion voting systems in 3 counties. Now, why only 3 counties? Why not all of them? Let's briefly talk about that. This was a compromise deal that was agreed to, at least in theory and in principle, by the plaintiffs and the defendants in the case. The balancing concerns are this. The plaintiffs, Sidney Powell's team, say, hey, we want access to the voting system software for forensic inspection, and we want to be able to inspect this stuff and make sure this is on the up and up, because we have witnesses who say that these types of voting systems have fraud built into them. In summary, this is a truncated summary argument, but that's the idea. The other side, the state of Georgia election officials, say we need voting systems. We need these voting systems to be in play and employed in our upcoming runoff elections. One which they have in December, I believe, which is a small one, maybe limited to even a few specific counties. I'm not positive of the details. And the bigger one being the Senate runoff coming up in January. And they say they'll need to update the systems to be prepared for the voter rolls that are expected, the ballot issues that are in play, the new ballots that are going to come out and all of that stuff, because they won't have, you know, Trump and other stuff on those ballots. They're not, they're limited in different ballots. So they say they need to update and alter the software for those things. The plaintiffs again say, hey, any alteration would destroy our ability to forensically inspect the machines as they were at the time of casting the votes. So in a compromise decision, the judge says, okay, these 3 counties, we will limit the impact to these 3 counties. We'll say that those have to be preserved and those machines cannot be altered in any sort of way. And then what he did was he set a hearing for December 4th to have a hearing on the other issues in the request. Namely, can Sidney Powell and their team forensically inspect these machines in the first place? Like, can they actually allow them to inspect the machines? That is a question. Will the inspection cause too much burden? Will it produce the results? So they have to present, you know, argument and evidence as to why that would happen, and the defendants would have to present argument and evidence as to why it shouldn't happen. And the other big issue that they wanted is they wanted the court, the district court, to enjoin or issue an injunction, the the election officials in Georgia from certifying the election results. They want to stop that certification at the court level. The court wasn't prepared to do that without a hearing on the issue, and that hearing was scheduled for December 4th. However, because of this appeal of the order that came out on Sunday, that hearing was canceled by the district court because, well, when you appeal an order, it goes to the appellate court, and the appellate court will may take jurisdiction over the case. And if the appellate court does have jurisdiction over the case, then the district court does not have jurisdiction to proceed. So since they appealed, the lower court canceled the hearing and said, okay, we'll have to wait for what the 11th Circuit says. Now, the 11th Circuit has said that the order below was not appealable, and we're going to go through the main reasons why it wasn't appealable. It's all contained in this order that I have on screen. But they said you can't appeal that order, and so this needs to proceed at the district court level. Now, again, that doesn't mean that the case is thrown out, but it does mean that the schedule has changed, and now there will be some delay in how that takes place. So let's take a look at why the 11th Circuit rejected this and what it means, okay? So the issue before the court is a narrow question of appellate jurisdiction. Has the district court entered an order that the appellate court has jurisdiction to review? The answer to that question is no. Therefore, we must dismiss this appeal for lack of jurisdiction and allow the proceedings to continue in district court. So there's a summary of it. No, the case is not over, and it will proceed in district court. But this is still actually a really big deal for Sidney Powell's team, because losing that December 4th timeline, the December 4th hearing, is pushed it back and may in fact push it back to December 7th, which would be after the weekend, before they can have a hearing, if they can even have a hearing on the 7th. And all of this needs to be done, finished entirely by, I believe, the 14th. The safe harbor provisions of the Electoral College are the 8th, but the Electoral College actually meets and votes on either the 14th or the 15th. So this stuff has to be done by then. We're coming right down to the wire on this, and having any sort of delay in the scheduling could really be the difference between victory and defeat in the lawsuit. So I gave you kind of the factual rundown of what happened. Basically, the court granted in part the request for some stay, for a stay or an injunction, I should say, on the change to the voting systems. They did not rule at all on the stay for the certification of the election results, or the broader issue of can they actually forensically inspect these voting machines. All right. So they issued that part of the order, or the order gave a partial grant of the requested relief and did not say anything about the rest. So that's what happened. And then here we have the answer. A few days later, the plaintiffs filed a notice of appeal as to the district court's Sunday night order. As a result, the district court canceled the hearing on the broader relief the plaintiffs had requested. So typically, we, the 11th Circuit, enter the picture only after the district court has considered the parties' competing positions and a winner has emerged. Less frequently, we review preliminary injunctions or orders that ask a particularly important and purely legal question. So since no hearing had occurred on the merits at this point, I mean, they had a Zoom conference hearing for very limited purposes of the stay, and they got that. But they have not had they haven't had a Zoom conference or any other kind of conference hearing over the full issues involved. And so this court won't have jurisdiction over that order yet, because they haven't had considered the competing positions and a winner having emerged. And typically what they mean by that is they mean the full case, right? So the automatic right of appeal is on a full decision on the merits, not usually on an interlocutory or in the middle of it order like this is. So those tend to have some special exceptions. So less frequently, they'll review preliminary injunctions, which this one is partially a preliminary injunction, but the part that they've enjoined was actually in favor of the appealing party. So that's kind of at odds with what you would want to do, and or orders that ask a particularly important and purely legal question, and the court's going to say no to that. So, getting to the court's argument, the district court has not issued one of those appealable orders. In this case, the district court issued an emergency temporary restraining order at the plaintiff's request, worked at a breakneck pace to provide them an opportunity for broader relief, and was ready to enter an appealable order on the merits of their claims immediately after its expedited hearing on December 4th, 2020. But the plaintiffs would not take the district court's yes for an answer. So the 11th Circuit wasn't too happy about this, clearly. They appealed instead, and because they appealed, the evidentiary hearing has been stayed and the case considerably delayed. For our part, the law requires that we dismiss the appeal and return the case to the district court for further proceedings. The 11th Court is issuing kind of a slapdown here, and so why did you do this? You got what you asked for. You got what you asked for or part of what you asked for in the order, and the rest of it was going to come today because they issued this ruling on the 4th. The rest of it was going to come if you just let it happen, but now you didn't let it happen. And so now we've got further delay. And I must reiterate, this was a big gamble on Sidney Powell's part because it may push the schedule to the point where they can't get the relief that they want. And that can be very devastating. Now, they'll certainly be asking for expedited relief, for an expedited hearing to be rescheduled, all of that stuff. They may not be able to get it. So even though the Sunday night order granted their request for a temporary restraining order in part and did not on its face deny anything, the order effectively denied their request because of the exigent circumstances involved. This is the argument that Sidney Powell has put forward. This is not the conclusion of the 11th Circuit. As the following sentence says, this argument fails for 3 reasons. So we're going to get that. So the plaintiffs, I should have highlighted that before. The plaintiffs argue that even though the Sunday night order granted their request for a temporary restraining order in part and did not on its face deny anything, the order effectively denied their request because of the exigent circumstances involved. But it didn't, though. So that's a big part of the problem. So first, the district court's order does not deny the plaintiffs their requested relief at all. In fact, there is no denial in the order. It simply says we will grant this partial relief until we can have a hearing on the merits of the relief requested, and once that has happened, we'll issue an order at that time. So notably, the Sunday night order gave the plaintiffs almost exactly what their counsel proposed as a temporary solution at the hearing. It, quote, identified a very limited number of counties and enjoined the defendants from erasing or altering data contained on Dominion voting machines in those counties, thus preserving them for future inspection. Then, of course, it goes on to talk about the hearing that they had, or that they had scheduled. So that's the first reason, because it gave them what they asked for, and it didn't deny them anything that they asked for. It just said, you got to wait until the 4th when we can actually hear this out. And in this case, the likely outcome is we would have had some sort of ruling issue on the 4th. So we would have had some sort of ruling on that hearing on the 4th, and that would have then allowed further proceedings, either an emergency appeal to the 11th Circuit at that time, or for them to go ahead and start forensically examining the machines. The court was willing to have a hearing and then issue an order on Sunday night following Thanksgiving in this case. The court has not demonstrated some sort of propensity for delay, right? They are moving on this case, and the idea that this would have caused some unreasonable amount of delay from the 4th is a little bit much, in my opinion. Second, even if the district court's order were properly construed as a denial of the plaintiff's request, again ignoring the fact that it did not deny anything, we do not ordinarily have jurisdiction over temporary restraining order issues. So they go on to address here this argument raised by Sidney Powell's team that this is an emergency, and they cite to Terry Schiavo. So we exercise the appellate jurisdiction over temporary restraining order decisions only, quote, when a grant or denial of a temporary restraining order might have serious, perhaps irreparable consequences and can be effectually challenged only by immediate appeal. This is in reference to Terry Schiavo's case. Terry Schiavo was a woman on life support, and they had competing parties, her parents and her husband, who had different opinions on whether or not she should continue on life support. And so in that case, they exercised appellate jurisdiction over the temporary restraining order decision because it involved the life or death of a person. So in this case, they say this is not the issue because they're not in the same position as someone about to be executed or a patient removed from life support. The irreparable harm threatened is that the voting machines will be wiped, erasing the data. But they got that relief. They got the relief that the voting machines would not be wiped. They got the relief that they asked for at the hearing, and so this is a problem. So the court says this isn't an emergency. The court below has addressed the emergency that you raised, that the data would be wiped, by issuing an injunction. And by the way, if they were to wipe those devices against the court's order, that could be construed as that there was actually, corruption on the. They would be able to draw a negative inference from the other party, and that would be actually very bad for the people who say that the election was not corrupt in Georgia or whatever. It would be very good for Sidney Powell's team if they actually did that, theoretically. That, however, wasn't the case as far as we know. The injunction on wiping the data is still in place. It was a 10-day injunction, so they still have a couple days left on that. So hopefully they'll be able to get the hearing rescheduled before that expires, but they may not now. So had the plaintiffs, here's the court's ultimate conclusion on the second point. Had the plaintiffs not appealed the district court's Sunday night order, the district court would have held the evidentiary hearing it set for December 4th, and by now would likely have ruled on the plaintiff's broader requests for injunctive relief. And then they go on to say afterwards the plaintiffs could have appealed. So that's the second issue there, is that there wasn't an emergency in this order justifying appellate jurisdiction for the 11th Circuit. Third, and for many of the same reasons, the district court's Sunday night order was not appealable preliminary injunction order masquerading as a ruling on a request for a temporary restraining order. So they're not saying that this was, or they're saying this order was not merely masquerading as a ruling, right? Like this wasn't an order that just is secretly something else. It's just not appealable. But those are the same sort of issues they've addressed before. So again, a summary recap of what happened. They had a hearing set for December 4th. They had a temporary stay on the tampering of the voting machines until that, for 10 days or until the December 4th hearing occurs, whichever comes first. Since that hearing will not occur and did not occur at the time, that the temporary stay should still be in effect, or the temporary injunction should still be in effect, and those machines are not to be altered. So Sidney Powell's team can request an expedited hearing on this issue. I'm sure they are likely already working on that. However, when that hearing will occur we'll have to see. We'll have to see. But they took a big shot on appealing the order, and that canceled the hearing they would have otherwise had. That could have caused a delay that could be fatal to the case. We'll have to see. But if you read the headlines out there that says the 11th Circuit has tossed out Sidney Powell's case, that's not actually true. What they did was they rejected a request for the appeal of a interlocutory order, a partial order on a preliminary injunction request, and they rejected hearing that appeal on the issue, and then they handed the case back to the district court to proceed as it will. So the case is still active. This is not automatically fatal to the case, although it does push the timeline back and make things very, very complicated. As I said before, they're on a very tight schedule, and every minute that goes by is potentially damaging to the plaintiff. So that is the news on the Kraken lawsuit in Georgia. I hope you guys find these videos and these updates informative. If you do, please hit like and subscribe, all of that stuff. Share it around, help spread the word about what's going on. Thanks, guys. We'll talk to you soon. Have a good day. Peace. Peace.